Friday afternoon is...
Thank you very much
it
for...
was imposed upon me by Jordan. It was not of my choice.
Thank you very much for this very witty and very enlightened presentation. I particularly liked your way of analyzing apparently trivial cases in terms of the high principles that underpin them, like the right to equality. You could have probably gone ahead and explained that monkeys are not just monkeys. Monkeys are untouchable because they're symbolic of the sentiments of the majority. Could I get the conversation started by asking a question myself? Doesn't the statement of President Pranab Mukherjee constitute a contempt of the court?
No, certainly not. No, certainly not, because it was not the court sitting in a certain way. The court had invited him to share his thoughts and views on the issues that they were debating. And when I had also been invited. I had a half-day session with them on various issues which were raised, and we were discussing them. So it was a free and frank discussion between the justices and other participants like me and others. And Pranab Mukherjee over there said, I quoted him because, well, he's the President of India and he said something. Well, me and a couple of people like me also said lots of things that we had to say, but I just quoted President Mukherjee. Yeah.
Thank you.
They had asked for his opinion.
Okay, Mr. Rai will be happy to take your questions and comments. Okay. Would you like to identify yourself and then ask your question?
Thank you, Mr. Rai. I'm Nihit Goyal. I'm a PhD student at the Lee Kuan Yew School of Public Policy. I have two questions. My first question is on why you think the Supreme Court of India has gone possibly towards judicial overreach, if it has. Do you think it's a failure on the part of the executive and the parliament to some extent? Or is it just that it's sort of keeping on to its powers and increasing them? And my second question is not directly related to your talk, but if I remember correctly, the issue of overreach was also raised when the CAG looked at the 2G and the coal allocation and whether the CAG had the right to go into the details of the policy. So I would be interested in your views on that. Thank you.
I'm not necessarily expressing my view that the court has overreached. Right in the beginning, I prefaced my presentation by saying that there's a viewpoint emerging in the country that the judiciary is overreaching. I presented some cases where you and I can come to an independent conclusion whether it constitutes overreach, number one, and if it does, is it for the right causes, even if it does. Some of these I do believe that where fundamental rights are concerned, where Parliament is passing legislation saying that no court, for no reason, will interfere with any legislation or amendment passed by the Constitution. I think the very fact that the Constitution provides for judicial review, the court has only played its role. Now, the other issues, we have to take a view on it. That's why I said I'm not taking a view. I'm leaving it open to all of you to take a view. But the debate is very current in India, whether it constitutes overreach. But the 6-7 cases that I pointed out, this monkey menace, etc., what does the court do if these issues have been agitated in the high courts? High courts have passed the verdict and the appeal comes before it. Does it just dismisses it outright, or does it takes it into consideration or not? Also. So, I mean, that's the issue of debate, whether it's worthwhile for the court to take cognizance or not, which means accept the appeal or not accept it. About CAG overreach, I presented a seminar over here about whether it was overreach or not overreach, and besides my own viewpoint on it, this issue had been agitated by the government before the Supreme Court itself, whether after presidential reference, whether the CAG had the mandate to do the kind of audits that they were doing, and the Supreme Court has passed a verdict which said that the CAG is not just an accountant, He is a constitutional authority, and the Constitution wanted him to perform the roles that he was performing.
Dr. Jivanta Shetty.
Thank you, Mr. Rai. That was very enlightening. I have a question of interest. You mentioned in your opening remarks that citizens perhaps have to take more of a role, and that brought to my mind the Right to Information Act. What is the Supreme Court's position on this? Has there ever been any tension? I mean, is there ever a feeling that that's citizen overreach in a sense by overuse of this act?
Actually, there are two parts to the question that you asked. One was where the Supreme Court itself, whether it should be subjecting itself to the right to information. It has taken the view that it should not. We can take views of it. I would sincerely believe that they should also say that we are part of the RTI. Let's be transparent about everything. I think it would have been a good example if they had done that, but in their own wisdom they chose not to, for whatever reasoning that they had. But yes, there are a couple of verdicts which have come from the court saying that right to information is a right granted to the citizen for very good reasons, and you should not exercise it for very frivolous reasons. And lots of things had been clubbed where people or government went to the court after it had appealed before the Central Information Commission. Central Information Commission did not take the right decision probably. So the government itself or the institutions went before the Supreme Court, and the Supreme Court said, for example, one of the questions under right to information was, how many cars does the Punjab National Bank possess? India-wide. Now, how do you gather that information? Or even if it is gathered, you can gather it probably. I mean, the court's query was, how is it of public interest? This is it's a right to information, but it's coming as a public interest litigation. But why? I mean, you have the right to information, but how do you gain by this information? So such frivolous things, the court has taken a very harsh view on it. Thank you.
Dr. Ranoja Sen.
A couple of quick questions. One is, as far back as 1980s, someone like the eminent scholar Upendra Bakshi had labeled the Indian Supreme Court the most powerful, or one of the most powerful Supreme Courts in the world. And this was, I guess, following the PIL revolution that you talked about, whereby a simple postcard address to the Chief Justice could be treated as a litigation. It was also, I guess, in the sort of post-emergency era. So, how has this story changed significantly since then? That's one. What would you say has been sort of the recent trends, or has it been? It has been always activist. It remains so. And again, in the 80s, you mentioned the 1982. What was it? The Gupta versus where the Supreme Court reaffirmed the decision that the Supreme Court itself will appoint its own judges, which is again very rare. The second is an article around 2000, Lloyd and Susan Rudolph, the political scientist, had written. I think it was called "Redoing the Constitutional Design." I think that was the name of the article, where they talked about institutions like the Supreme Court, the Election Commission, and the presidency, the president, stepping in. And this kind of addresses the question you raised, precisely because there was a lack of public trust in both the executive and the legislature, and this allowed these institutions, which they call the regulatory institutions, to step in. And the CAG at a later stage, they could also be classified as one of the institutions. So it was, and if you look at opinion surveys too, these are the institutions, Election Commission, Supreme Court, which always ranked very highly on public trust. So this enabled the Supreme Court in a way to expand its ambit, which was which had started in the 80s dramatically, because there was middle class public validation of the Supreme Court's actions. And in fact, a lot of the PILs are actually a collaboration between civil society groups who put in the PIL, and then the Supreme Court acts on it.
See, in fact, it was post 1979 or 1980 that it's believed that the Supreme Court has become very assertive, or the courts rather have become very assertive, and the judiciary has started playing a role which is larger than possibly what was foreseen for it in the Constitution. And as I mentioned about the National Judicial Appointments Commission, probably the only court in the world today which decides on its own appointment within itself, totally insular to that, and its recommendation is binding on the president. So Upendra Bakshi has written about it, and lots of others have written about it all through. You will find just about half a dozen articles from very prominent people emerging every year, which says that the court has become very powerful, and it's become powerful through this public interest litigation arm itself. A remarkable example of this is that the court wanted to know why airlines are not flying to Shimla, and insisted that, well, there's an airfield there and you are not flying there because it's not remunerative. Yeah. Whereas Indian Airlines or Air India, whatever it's called, has a social function also to perform, being public sector, and you should fly there. Now there is a comical aspect of this interest taken by the court on Shimla, which was told to me by one of the ministers. He says that the Chief Justice's father-in-law and parents-in-law are in Shimla. They are obviously very old, and once in a while he and his wife want to go and visit them, and he finds it very inconvenient to drive down to Shimla from Delhi, or to take a train or fly to Chandigarh and fly up from there. So Shimla, if he could fly to Shimla, he could fly in today, visit them over the weekend, next day he could fly back, and that's why he's showing so much of interest in Shimla. But that's the aside. 2001, there was Chandrachud was the justice who went in for Constitutional Amendments Commission had been set up, in which a lot of these issues came up, whether there is need to redesign the Constitution in some ways, the Constitution needs to be amended, and among others, even the CAG came up for a review. And they asked the then CAG whether there is need to make the CAG a multi-member body. It's a single-member body today, unlike the Election Commission, which became a multi-member body. And the suggestion given by the then CAG in 2002, and then reiterated by me in 2012 was, sure, make it a multi-member body. There are multi-member models all over the world, but each one of these models comes with a certain amount of structure and powers attached to it. So when you are making it multi-member, the power also becomes multi-member. So whether it was the Election Commission or the Information Commission, which came later, these had come up for redesigning, but ultimately the Parliament decided not to interfere with that. At least the CAG setup, because in the CAG setup there is the Article 148 says there shall be a Comptroller and Auditor-General, which means single body, a Comptroller and Auditor-General. So if you have to make it multi-member, you have to go in for amendment to the Constitution again, 2/3 majority, etc., etc. But the most remarkable case of this is the National Judicial Appointments Commission, which has seen this tussle between the judiciary, and there the judiciary has emerged as really powerful, where its writ runs, and neither the Parliament nor the executive decided to take on the judiciary and the verdict that it has passed.
Thank you. I have actually 3 names on the list at the moment. My own, Anish, and then yourself, and then we'll go on further. Here is then my question. I come before you. And Mr. Vinod Rai is an avid tennis player, and listening to him, I got the feeling of this ball going from player to player. There's a kind of constitutional teasing that goes on between a number of bodies, and the pot doesn't boil over. And that's my question about the political culture of acceptance of these verdicts. And the comparative question is, across the frontier in Pakistan, the pot did boil over. The Supreme Court did overreach itself. Now, in India, it's there's a brinkmanship. There's a brinkmanship because the minister is actually sent to jail for contempt of court, but the fellow goes to jail rather than going on a rampage. So why is it that where does this political culture come from of accepting countervailing forces between the need for executive action and the need for restraint on the executive action? And if India and Pakistan both come from the same colonial tradition, why does it work one way here and another way there?
I think it's largely because we practice democracy of a very free, vibrant kind. And it's more the respect of the law, but most importantly, it's public opinion. Because let's take the Judicial Appointments Commission. If either the Parliament had what I would call a certain credibility today, it would have had the courage to take on the judiciary. On the other hand, if the judiciary had the credibility to say that, look, we are well within our rights to say that the collegium itself will decide, whereas in the judgment, I didn't bring it out, it says that the collegium will decide, but it needs to be fine-tuned. Those are the operative portions of it. Now, there is a certain amount of erosion, I didn't want to say it, erosion in the credibility of both these structures, or all the three of the structures. Judiciary today, because of huge amount of pendency in it, judiciary today, for instances of, what should I say, irregularities or less than normal display of integrity, in instances have come up for notice where probably probity has not been displayed by the judges themselves, makes them weak in some ways. So that's why the kind of thing that you see boiling over, there is a fear of public opinion in India. That's why I called it a vibrant democracy, in the sense that public opinion today, and I said it earlier also, where the citizen has come center stage, and the citizen is very discerning, is very demanding, is not fearful of speaking his mind. He has begun to question these institutions, including the CAG or the CEC. You will find articles appearing every other day. So somewhere there is a fear in these institutions also, saying that, look, how will public opinion read us if we overreach? And it boileth over, if I can say, in Pakistan. But I think we are still practitioners of that kind of vibrant democracy where public opinion still matters and it is not being stifled.
Thank you. Anish.
Yes, my question for Mr. Rai is regarding a case that we didn't discuss today, which is the divorce of Shah Banu. How is it so that the Rajiv Gandhi government was actually able to deny the woman of her rights that she won by the Supreme Court of India? And and is this actually a question of who's the final who's the top? Is it the government or the Supreme Court in this case? And given this case, does it also shows that we need the Supreme Court in India to actually safeguard the rights of certain minority groups? Because different the government, they probably have certain vote banks that they need to safeguard.
Actually, that case was not a case that much of minority or anything. It was just an exercise of pure fundamental rights of the lady. She was saying the rule of the law is the following: I have the right to liberty and equality. Now, if there is a Muslim personal law, does it override the constitutional law which is made available to me? And she questioned that right up to the Supreme Court, where it had nothing to do with Rajiv Gandhi government. It was a verdict of a lower court. And then which came up for review by the higher court, and the court took the view that the constitution provides all those rights to you, and those rights prevail over anything else.
I think also a clash between a particular section in the IPC, which grants a certain amount of maintenance.
did not.
Supreme Court was validating where it clashed against so the petitioners argued it went against the Islamic Personals. It wasn't really a
Government issue.
I think
Yeah.
activism came in when the court actually asked for a uniform civil code.
Civil code later on. That would have been, yeah. But anyway, it just made an observation and said there should be a sort of. But it finally didn't materialize in that way.
Please identify yourself.
Sure. My name is Ananta Nageshwaran. I'm an affiliated faculty with the Singapore Management University. I also write a weekly column for Mint Financial Daily in India. Sir, in the last couple of months or 3, I have myself written 2 columns on what I call critarchy or judicial overreach. So in that sense, I feel that if we have a second best world where the executive is not executing its responsibilities, is judicial activism creating a third best world of confusing and diluting responsibilities? And you yourself alluded to the fact that in a couple of instances, judiciary hasn't set its own example. In the NJAC case, from a normal perspective, it is a conflict of interest for the judiciary to sit in evaluation of its own appointment. So that's a natural conflict of interest. And the second one, you mentioned also that the judiciary exempting itself from RTI requirements. So given this instances where the judiciary does not live by the rules it prescribes to the executive, then definitely the accusation of overreach acquires a certain legitimacy. And there was a Business Line article 2 weeks ago quoting you that if the bank executives do take decisions in terms of applying haircuts on non-performing loans, they may not be subject to vigilance, oversight, or on that particular aspect. I think there is a sort of a relationship to the issue that we are discussing here, and assuming that the article quoted you correctly, that some enabling provisions will come into force soon. So I think the risk is that even though it's a long-term process, the executive is not allowed to grow and execute its responsibilities if judiciary takes over longer and longer into the executive's roles. Even if this is a long-term process, what I feel is that the judiciary taking over decisions on who should enter Sabarimala and when, and who should fly to Shimla or not, I think we are definitely flirting at the boundaries of executive decision-making, sir. Thank you.
I'm happy at least you said flirting at the boundaries only. We haven't crossed the boundaries as yet. See, the issue is how long do you and I'm not talking about the judiciary, how long do we wait for the executive to take its decision? We waited for 42 years to wait for the Lokpal, for the Lokpal to come. Every parliament they say yes, we will want it to come, but it has not come. So our own representatives in parliament decide that, well, I want the Lokpal, for example. You may want the Lokpal, but you and I have a representative parliament who is not fulfilling our what should I say, our objective or our feeling. Now, is that a trust which we have reposed in him being not fulfilled? So how long does the judiciary wait? That's why I said if somebody cedes space, you cede space by taking a decision not in time. You delay the decision. So do we wait indefinitely for the executive to take us? Because the executive does not take reasons for some which may be politically inconvenient. The timing may be politically inconvenient in the sense you're facing an election, so you don't want to take a decision. Now, by then, harm is being caused by whatever is the issue which is being agitated by the public. Maybe a pollution case, maybe that, what was it called, odd even or whatever, that also went before the court. The court decided not to interfere. So the issue is how long does one structure of the constitution wait for the other structure to fulfill its role? And that's why it seems to have stepped in along this thing. I'm not saying that it's overreach or not overreach, but the issue is just this, how long. So when you say that executive is not allowed to grow, fair enough. But how long do you wait for the executive to grow?
So the only way is for the court itself to set an example by the time it takes to dispose of cases. When the Chief Justice supposedly breaks down for lack of adequate
He actually broke down.
I think to be honest, I was relatively unimpressed, because when you accept a lot of frivolous cases, then obviously you have commercial disputes where you have a legitimate role to play. Then what is, for example, what is the mechanism by which they prioritize cases for them? So I think the only way they can allow the the executive to grow into its role is also for them to set an example in the way they conduct themselves, which hasn't happened.
That's exactly why I said it's an issue of credibility. Each one of us has a chink in our armor. Since we have a chink in the armor, we can't go out and kind of orchestrate our issue more than something else. So when they struck down the parliamentary amendment for the NJAC, they had to take recourse to some sentences that they added in the judgment saying that we will fine-tune this. And obviously there are some fallacies. They will have to be rectified over a period of time, which was their own conscience speaking up. So I'm not saying that what they did was right or either way. I mean, it can be read both ways. But the issue is just this, where not so much the executive or the parliament is involved, where my fundamental rights are being infringed. What do I do? Do I wait? I appeal before the government, but government procedures being what they are, etc. Pendency in the courts, yes, huge amount of pendency is there. Priority, who will decide the priority? Again, if we don't leave it to the court to decide the priority, we can't have an outside element deciding on the priority of the cases. So somewhere we have to leave it to the better judgment of that particular organ of democracy to decide for itself. But then what you say is the bottom line, that we can't afford to have an Achilles heel of our own. So whether it's an RTI or anything else, you have to be, Caesar's wife? What's that? Caesar's wife has to be above suspicion, isn't it? That's it. So you have to declare yourself to be above any kind of suspicion.
Okay. I have got 3 names on my list, and those would be the last for today. Dr. Sojin Sin, Shuli, and Rajiv. So please ask your questions. Mr. Rai will take them.
My question would be very basic. I tried to understand India's Supreme Court as very interesting but very difficult institution. And I have a question about the process of reaching Supreme Court as an individual or any organization or community. Well, I mean, for my understanding, other countries have very clear-cut spheres for 3 organizations: executive, parliament, and judiciary. And this question addresses the dynamics between India's Supreme Court and High Court as well. I mean, who defines the spheres for High Court and Supreme Court? And is there any individual can plead to Supreme Court with any kind of issues like regarding their fundamental rights and anything, because for other countries there is a multi-level approach process, right? So that would be
it's defined. It's very well defined by this.
Actually, if it's all right with you, we'll take all 3 questions because of the time.
Yeah.
Rajiv, will you give the microphone to Shuli? Yeah.
I actually have 2 questions. My first question would be, why do you think the courts in India are so reluctant to pass hate speech laws? And the second one is related. Do you think that not just the Supreme Courts, but the entire legal machinery in general in India is actually moving towards being more focused on public interest when, for example, last year a boy got arrested for forwarding a post on Facebook which allegedly accused some politicians of some misgivings, when most seditious, for example, politicians were arrested for seditious cases, whereas politicians who commit inflammatory rhetoric during elections often go off scot-free after they apologize or they show remorse. So do you think that the Indian legal machinery is moving towards protecting the electorate or protecting themselves?
Thank you. Rajiv.
My question is related to directive principles of state policy and fundamental rights. In several cases, court has read it together. For example, directive principle says that protection of cows. So some states have passed laws to protect cows, so beef is banned. But also some people claim that it's my fundamental right to choose what I eat or drink. For example, in Bihar, liquor is banned. Even if I am transiting Bihar with liquor, I can be imprisoned. So how in such situations judicial activism and fundamental right things are balanced? Do you see court, how court balances fundamental rights and directive principles of a state policy?
Thank you. Mr. Rai.
Who defines the hierarchy? It's laid down in the Civil Procedure Code as well as the Criminal Procedure Code about you represent, where do you represent first. But issues which involve fundamental rights, and if you can in your petition prove that it affects a large number of people, can be agitated before the Supreme Court. It's left to the Supreme Court to decide whether it's going to hear that or not. So that's why these issues of pollution in Delhi, etc., the court decided to take it, because it you have to argue in your petition that, look, it affects 70 lakh citizens in Delhi or 1 crore citizens in Delhi, and hence I'm agitating before the Supreme Court because the interest of so many people is involved. That's all. Otherwise, it's defined that you go to the district level courts and then you go to the high courts, and only appeals come before the Supreme Court. The hierarchy of appeal has been laid down. But the instances which that's why, for example, that motor vehicles case, helmets case, which I pointed out, was agitated in the Andhra and Karnataka right up to the High Court level. The High Court had passed its verdicts, and in appeal, because it involves supposedly fundamental rights, it came before the Supreme Court, and the Supreme Court decided to hear that appeal because it says wearing helmets was not violative of infringement of fundamental rights. Hate speeches, normally what happens is this issue has been agitated, but the courts, it has not been agitated before the Supreme Court as yet, but there are some cases pending in high courts. But the courts have taken the view that this better forum to agitate on this is before the Election Commission, because the Election Commission has the power to disqualify a person who, as a member of any of the legislative assemblies, when they make inflammatory speeches of the kind that are being made. But some ways, maybe a public interest litigation which bundles a few speeches together does not appear to have come before the High Court or the Supreme Court as yet. But I have a feeling it will, because a large number of these things are happening. But there is, I would say, an undercurrent of maybe fear or hesitation, because these are the very elements which are, what should I say, omnipresent in all parts of society, where they say, well, if you go against me, you suffer the consequences. So there may be an undercurrent of fear in anybody agitating against those speeches before the court. Fundamental rights and the directive principles, I don't think anybody has agitated before the court saying that, look, this order of prohibition is denying me the right to drink, take liquor. I mean, it will be a very interesting, I mean, you have a very valid point. It will be very interesting for somebody to agitate before the court that this imposition of an order by the Bihar High Court impinges upon my right to drink. Because I'm a citizen of India and I have the right to drink wherever I want. I don't think this issue has been agitated, so that really I'm not in a position to be able to tell you which way the court will, I mean, how will it make the balance. One is a directive principle and the other is my fundamental right. So I think under the directive principles, the government must have taken a view and ascribed to itself the power to ban liquor. In the cow issue, Maharashtra government the court has taken the view that nothing denies you from consuming beef as long as it is not slaughtered in Maharashtra. I mean, it's a very funny decision. I mean, verdict. How do you find out whether it's slaughtered in Maharashtra or not? But that freedom has been given to an individual that yes, you can consume beef in Maharashtra.
Thank you so very much. Listening to you, reading you, and working with you reminds me always of that old expression, "Quis custodiet custodes," who will guard the guardians. I mean, that's the wisdom of the Indian system. Mr. Rai has been as high a civil servant as possible, and then at the end of his career, he's set up to watch over the civil servants and the ministers.
No, make up for lack of education by coming here.
That's what keeps India going, and the pot keeps boiling but doesn't boil over. I think that is what ultimately explains the resilience of Indian democracy. Anyway, it's our job, the mandate of ISAS, to connect South Asia to Singapore and Singapore to South Asia. This we do by conversations like this, which opens up the Indian system. And the second half is done by you all by asking Singapore questions about South Asian reality. And we don't just do this, we then put it into writing, because that's the book that Mr. Rai is writing about Indian institutions. And this is one of my very pleasant obligations to package this knowledge and make sure that we meet our KPIs. That's how this institute works. But the institute also has a rule that we never allow even family to go away empty-handed. So I've selected a gift for Mr. Rai. This is called Looking Ahead, India, Singapore in the New Millennium. This is celebrating 50 years of diplomatic relations between Singapore and India. And they're obviously looking towards the next 50 years, so more conversations and more tennis between two good partners, directive principles, fundamental rights, states, center, people, the executive, and so on. Thank you very much.
Thank you.